All right, we're live.
Hey, good evening, everyone. Thank you so much for joining us today to talk about our constitutional foundations here. We're facing
Live.
what I would say is a constitutional crisis.
Hey,
We've
good
seen
evening, everyone.
We've seen a number of a rise in executive orders. We see the executive agencies that are being closed, the rise of the use of the pardon power. So we wanted to talk about a number of these issues, and I'm very honored to be joined by our Senator Richard Blumenthal, our U.S. Senator, and our President of our Senate, Senator Marty Looney. We're gonna focus on some of these sort of key areas, particularly in the when it comes to executive orders in the last week. And I'm going to start out just to make sure, as a teacher of the Constitution and a scholar of constitutional law, that we're all on the same page when it comes to, our sort of structure of the Constitution. So let me just give a quick overview of a framework of a few of the constitutional structures, and then I'm going to turn it over to Senator Blumenthal to talk about what is happening in a contemporary sense with the pardon power and what are some of the constitutional problems. So I want to just highlight in the very beginning that, our Constitution starts out with this famous phrase, "We the people." The Constitution, most importantly, is about public accountability. It answers to the people. And I want you to be aware of a clause that many people don't focus on this. I think it's the most significant clause and the most important act our framers have ever constituted, and that's Article 1, Section 9, which is to have no titles of nobility. That means that when you serve the office, you serve the office. It's not about the individual, it's about the person. And when you leave the office, you leave the office. So what we're really trying to think about today is, what should these structures of government look like? What should these offices look like? Um, and to that end, we have, just so we're all understand, we have a system of government that is a constitutional democratic republic, meaning we have direct elections, direct and indirect elections, but we also have institutions like a legislature, an executive, courts that are there to interpret those rules. We have a parallel system of government. So we talk a lot about the federal government, but we also have state governments. And we're going to talk about the sort of the limitations of federal power in terms of being able to commandeer the states or require the states to act in certain ways or not. States are separate autonomous units, and that we have their own sort of power and own jurisdiction, and that's separate from the jurisdiction of the federal government. And that's important for everyone to keep in mind. And when it comes to the constitutions, every state has their own constitution because they're separate autonomous jurisdictions. But then we also have the U.S. Constitution, the federal Constitution. So we're going to talk a little bit about that separation of powers, Senator Looney in particular. And then we're going to look at the separation, the division between the federal power and the state power. But we're also going to talk a little bit here about now separation of power. So both at the federal level and at the state level, we have, three branches of government. So the lawmaking power, which is always with the legislature, that's Article 1 of our U.S. Constitution. Article 2 is the executive branch. And those executive agencies that you see, some of those are regulatory agencies. Those fall under the executive branch, but they have been created by Congress because the Article 1, the lawmaking power, is with the legislature. So we're going to look at sort of the relationship between Congress and the executive, and then Article 3, is our third, is the independent judiciary. So what we want to turn to is really want to turn to Senator Blumenthal, focusing too on that. What is that power in Article 2, the executive power? And how has that been used in the context of pardons? And how does that perhaps go beyond what's permissible, or that what goes beyond the limit of that separation of powers between Articles 1, 2, and 3? And then we're gonna turn after that to Senator Looney to talk about this relationship between the federal governments and the state governments, and where, in fact, the federal government is able to, or under these executive orders and the executive mandates, when they're able to tell the states what they have to do, and when states can say, "Hold on, we have our own set of guidelines, we have our own set of rules, and we have our own autonomy to do this under the 10th Amendment." So we're going to look at all of that. We're going to look at the three powers, and we're going to look at the two levels of government. So let me stop the PowerPoint there, because I want to turn it over to Senator Richard Blumenthal, who has been looking carefully at the pardon power and is in fact proposing a constitutional amendment on some limits that should have been long discussed. So let me turn it over to you, Senator Blumenthal. Thank you so much for taking the time to be here.
Thank you so much. I'm so honored and excited to be with you. When we planned this session, I thought I would be in my office in DC at the United States Senate. And instead, because of a plane delay, I'm actually in my car going from Dulles Airport to the Capitol, where I have to vote at 5:30. So forgive me for being invisible here. My Zoom has not picked up the visual part of the session, but I hope everyone can hear me. And let me come right to the point. First of all, I'm honored to join two really sharp, insightful, incisive lawyers. They're really crackerjack state senators, but they're also really good lawyers, and they know this stuff even better than I do. Marty Looney has been a leader for literally decades, somebody I admire so greatly. And Sujata, thank you for your scholarship and your teaching. Let me sort of come right to the point, a thumbnail sketch of how the world looks to me right now. When we take oaths of office, whether it is as a private becoming a member of the United States Marine Corps, as I did a long time ago, the Marine Corps Reserve, or as a United States Senator, or as a state senator, or as U.S. Attorney, all of us as officials of government raise our right hand and we take an oath. It's an oath not to the president or to a king, it's to the United States Constitution. We all swear to uphold the rule of law. And what I am seeing in my world, and it's our world here in DC, is frankly a president who is violating the law in freezing funding, in imposing a hiring freeze, in firing inspectors general, in eliminating an agency of government, USAID, in these executive orders, including abolishing birthright citizenship. He is basically violating the law. He is taking the law into his own hands. He is violating the Constitution as well as the law. And we can talk about why that is so. For example, the freezing of funds. I was just this morning at a brownfield site in Waterbury with the mayor of Waterbury, Paul Pernaruski, and Congresswoman Hayes, because they have suspended a loan fund that's necessary for the cleanup of brownfield sites in Waterbury without justification. It's a violation of a specific statute that creates a revolving fund for loans that go into that cleanup. But the suspension in that instance and again in all these actions has very specific harms, practical, real life effects on the lives of everyday Americans, just like tariffs. Imposing tariffs will raise the price of groceries and gas, fuel and food, clothing and cars. All of these orders and tariffs and other actions by the president have real world effects. And that's why I feel so passionately and so deeply that I will do everything I can to protect the people of Connecticut and uphold the rule of law. On pardons specifically, the situation is different because the pardon power is one of the only powers, and I don't know of another that provides for the same breadth of power where it is completely unchecked. We live in a country that has checks and balances. The founders really found an anathema in absolute power in any branch of government or any official. They wanted all the powers to be checked and balanced. That's why we have three separate branches of government, both at the state and the federal level, legislature, executive, and the courts, going to the United States Supreme Court, which can strike down a law or an executive action that violates the Constitution. And the courts are checking some of the executive branch actions, the freezing of funds, for example. But the pardon power is virtually unchecked because the founders took it from the English system where the monarchy, the king, could issue pardons. But I would argue that it was never intended to be used in the way that it has been used recently. And I will tell you very bluntly and candidly, it's been used in a way that I find antithetical to the rule of law by both Republican and Democratic presidents. I don't want to go into the details because we don't have time. I'd be happy to answer questions. But in my view, presidents on both sides of the aisle in the last 2 or 3 decades have used it in a way that would not have been used if there had been some check. That's why I believe there have to be guardrails. And I've proposed 2 means of establishing some limits. One of them statutory, consistent with the Constitution, which grants the president near absolute power. I have introduced legislation. It's called the Pardon, Transparency and Accountability Act, and it would require an explanation from the president as to why he's granting a specific pardon. It would require a statement of impact. It's called a pardon impact statement that would give the victim of a crime the opportunity to be heard, to oppose the granting of a pardon, and also the prosecutor who did the case that resulted in the conviction, criminal conviction, that the president is saying he will pardon. It will require a statement about the severity of the crime and why there has been rehabilitation that would justify the pardon. And it will require a statement of disclosure of any lobbying, any campaign contributions related to the pardon. Now, you may say that sounds unusual, but actually it's our Connecticut law. It's modeled on our Connecticut Board of Pardons and Paroles, where that kind of disclosure is required. In fact, our Board of Pardon and Paroles is composed of 10 full-time commissioners who rule on every single pardon. And they assess those exact criteria: severity of the crime, statement of the witness, opinion of the prosecutor, has there been rehabilitation, those same criteria. But the idea is, even if you were to have slightly different criteria, the idea is there should be criteria and standards and some full disclosure and explanation. I also have proposed something broader and more fundamental, which is a constitutional amendment. It would require that the pardon power, in effect, be a shared power, shared with the legislature, reviewable by the judiciary. So it would be more like other powers in our Constitution. That constitutional amendment obviously is going to take years to get done. Very much an uphill fight, just because every constitutional amendment is an uphill fight. But it would schematically follow the kinds of requirements that are imposed on every other power, which is a check and balance, a sharing, a sort of much more transparent and open process, as our government does in most other areas. And that's why I think this pardon power has to be reformed to regain credibility and trust of people. Right now, I think that the power of pardoning individuals convicted of crimes has been in the shadows. It's operated as a kind of black box. Nobody knows why or how presidents grant pardons. Sometimes they are the people who we would very much rather not see pardoned after significant costs of prosecution. You know, on the one hand, President Biden's been criticized for preemptive pardons of people who actually said they didn't want a pardon, even though the reason for the pardon is President Trump's threats to prosecute people broadly, like General Milley, or people who have opposed him politically, or others in President Biden's family. So President Biden pardoned them to spare them the cost and expense of a potential prosecution. But then President Trump's pardoned 1,500 people who were convicted or charged with crimes. Most of them convicted, some of them convicted of actually assaulting police officers and causing serious injury, maiming them, and in some instances contributing to deaths of police officers. So this pardon power has raised very serious questions, but I think the important point here is that our Constitution has been just the touchstone and the guiding light for our democracy over these many, many years. It has guided the American experiment. It has protected our liberty and rights in ways that no other country has achieved. And I think if we're going to improve our democracy, it ought to be through the rule of law, not abridging the rule of law, not violating our laws by the chief executive of our country or by anyone else. And I plan to continue to do everything I can to uphold my oath, which is to the Constitution and the laws of the United States and Connecticut, and to make sure that the rule of law is protected, our rights and our democracy are safeguarded. And I really appreciate this opportunity to talk with you a little bit about it. But most important, I would love to hear from you, whether it's personally or by email. Richard@blumenthal.senate.gov, richard@blumenthal.senate.gov. I'm sure we won't exhaust the questions or the points that we want to make here. I'm so honored to be with State Senator and President of the Senate, Marty Looney, and as my fellow speaker here. And I'm going to end there, and hope that you'll forgive me at 5:30 when I have to go vote. I'm in Washington, D.C. now and approaching the Capitol.
Thank you so much, Senator Blumenthal. And, really, it's a testament to your commitment that you're on your way to the Capitol to vote and you still join the Zoom call. So I can't tell you how much I appreciate that. And thank you so much for, outlining this difference between the constitutional power of the pardon power, which is constitutional, but it's been unchecked. And it has been argued that, that can be controlled in some ways by Congress. And then you've made suggestions for providing those guardrails, both through statute, through Congress, but then perhaps to create, an even more balanced power when we think of those checks and balances between all three branches of government to have a constitutional amendment. So thank you so much for that. And then there's a question here, when you're distinguishing that constitutional power that requires some guardrails and some more details in its application from unconstitutional applications now of so the freezing of the federal funds, and then the hiring and firing of federal agency heads, particularly for regulatory agencies that are actually under the have some legislative function, and so those before somebody is dismissed that is actually supposed to go through Congress. So there's a question in the chat about whether there's precedent for something like a private billionaire like Elon Musk to be running or effectively running or influencing the Treasury Department. And are these actions of President Trump to both freeze funds, to hire and fire, or to hand over information to those who may not be appointed, again, through this congressional process, is that outside of the law? And then what legal remedies exist to remove them from those roles, to stop that from happening?
It is entirely and completely unprecedented for a non-appointed, non-confirmed, non-government official to have access to this kind of power and information. And by the way, Elon Musk has authority not only to propose and recommend certain kinds of reorganizations, that's the authority he's been given by President Trump. He also has just taken access, his crew, access to the information about you that comes from refunds on your taxes. It comes from payments to you through Medicare or Social Security, any payments to you from the federal government. That information is in the United States Treasury. That information now is accessible to Elon Musk and his group of non-government, non-appointed officials. That is just, it's mind-boggling. And we are, so astonished, so absolutely aghast and appalled. We're trying to devise ways that we can stop it. Not easy, because again, the president is proceeding by an executive order, and we'll probably have to go to court to stop it because it is unprecedented, has no basis in law. But the violation of your privacy potentially is just mind-boggling. And when we say your information, it's your tax information. When you file your tax returns, this is now apparently accessible. When you are a recipient, or you're filing Social Security payments, you file, even if you're not receiving Social Security, you're paying into the Social Security trust fund. And I could go on at greater length, but I think you get the idea that this kind of accessibility, which he has gained because the Secretary of the Treasury is providing him with a pass, in other words, a sort of open the door function to all this information. And, here's what is really just, you can't make this stuff up. Elon Musk, of course, has government contracts. He is competing with other contractors. SpaceX, for example, is competing with other private companies. Jeff Bezos's company that is also submitting bids. These billionaires have companies that are competing in other realms of government contracting. So he is getting a huge advantage, and the other groups or billionaires in his circle, Peter, is essentially getting access to this information. So it could be a gigantic steal of private confidential information. I have been texting, I have been tweeting, I know it's now on X, and a variety of other social media. I've been trying to sound the alarm, but it is so deeply disturbing and just appalling. So thank you to whoever put that question. I think it's such an important point.
And thank you, Senator. I know you have to leave in 2 minutes, and just this question relates to that. Is there anything else Congress can do you think, besides taking this legal action?
We are looking at what we can do, either to try to get cooperation from our Republican colleagues. Remember, when you say, is there anything else Congress or the United States Senate can do, I'm in the minority. Democrats are in the minority. Republicans so far have been very pliant to Donald Trump. They have been so meek and timid and virtually silent about all of these violations of law. They have voted for all of the nominees so far. Gates was withdrawn, but the others so far are going through committee with Republican votes. So is there anything we can do? If we get cooperation from our Republican colleagues, we can act legislatively, but that will be a challenge.
Thank you so much, Senator Blumenthal. I know you have to leave in 1 minute. You have to be on your vote. So I just want to thank you and for taking the questions now so that you can be here to answer them and to, having given your contact information for anyone else to follow up with you. And we'll provide that as well.
Richard@blumenthal.senate.gov. And maybe you can, if you don't mind, you can collect them, some of them anyway, and, I can answer them. And we can do it together.
Absolutely.
And now I'm going to turn all of the really tough questions over to Senator Looney.
Exactly.
But
thank you so much.
I am a really big fan of both of you, and I really apologize that I can't spend the full hour with you. But I know you both understand the importance of voting and getting there on time.
Thank you so
much. Take care.
Thank you so much, Senator Blumenthal.
Bye.
And thank you. And I'm honored now to turn it over to Senator Looney. So, one thing that gives me hope is our state, Senator Looney, that we have protections that go beyond the federal constitution, which is why I started with our two systems of government, the federal system and our separate autonomous state system. It's so fortunate for us to be under your leadership. And really pushing through the issues that matter most to people. So I don't know. I want to, given our conversation, I want to know if you, wherever you want to start, if you want to start about talking about that relationship between the state and federal government, where we are, maybe what we're doing in Connecticut to provide hope for people. And then there are some questions in the chat about the state level as well.
Oh, sure. Absolutely. First of all, I want to thank you, Senator, for helping to organize this conversation, and to Senator Blumenthal for being part of it, and just shows how conscientious he is. No matter how busy he is, he always wants to reach out and be part of community conversations. And he, of course, is a great legal scholar, as well as being an elected official that just out of law school, he was in the rarefied atmosphere of being a United States Supreme Court clerk, and then was a United States attorney for Connecticut, and then ran for the state legislature, served in both the House and the Senate, and was then 20 years our attorney general before being elected to the U.S. Senate. So he is certainly a scholar as well as a public servant, as are you, teaching constitutional law as you do. As you said, our system, which we describe as our system of federalism, involves dual sovereignties, the federal government, but also the state governments. Our original organizational principle, the Articles of Confederation, was set up with a focus on state authority to a diminution of federal authority, because the federal government only had the powers that were granted to it by the states. That system was seen to be inefficient, and the new nation threatened to be breaking apart before it was even founded. So the Constitutional Convention was held in 1787 for the initial purpose of revising the Articles of Confederation, but it became clear after a while that no mere revision was going to be sufficient, and what had to be done was a new governing document had to be submitted, and that became our U.S. Constitution, with the balance between state and federal power, our system of dual sovereignty. So it's also, just as a side note, it's interesting to note that sub-state levels of government, namely counties and municipalities, are nowhere mentioned in the United States Constitution. So whatever powers they have are derived powers that are given to them by the states, either through state constitutions or through state statutes. But in terms of federal and state relations, probably the most important point is the 10th Amendment. Now, the first 10 amendments to the U.S. Constitution that are collectively known as the Bill of Rights were adopted and approved as a package after the original Constitution had been ratified. But during the debates over ratification, there was growing concern that the rights of states and the rights of some individuals were not adequately addressed in the original Constitution. So the 10 amendments, especially the Fourth, Fifth, and Sixth Amendments, dealing with the rights of criminal defendants, and then the 10th Amendment dealing specifically with the issue of federalism, and the Ninth Amendment also dealing with the issue of implied powers. They were the drafters of the Constitution, most of whom were attorneys, were sensitive to the idea that the that just because all rights were not necessarily articulated in the Constitution did not mean that other rights did not exist beyond those mentioned in the Constitution. But the 10th Amendment in particular says that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people, meaning that in the event of doubt or ambiguity, the tilt should be toward state authority, and that so the ambiguities and the any area where there is a dispute, the tilt should be toward the states, not the federal government, which is in the as you mentioned at the beginning, the federal government is limited to its enumerated powers and those that have been held to flow from those enumerated powers. But there are three major U.S. Supreme Court decisions over the last 30-something years, all of which uphold the principle that the federal government is prohibited from and limited in trying to compel or commandeer state officials into carrying out federal policy. Interestingly, all three of those decisions, the majority opinions for the U.S. Supreme Court, were written by Republican appointees to the U.S. Supreme Court. Justice Sandra Day O'Connor, Justice Antonin Scalia, and Justice Samuel Alito. The first of these was in 1992, and the decision was rendered by Justice O'Connor in a case called New York versus the United States, where Justice O'Connor wrote that a federal waste management law, quote, would commandeer state governments into the service of federal regulatory purposes and would for this reason be inconsistent with the Constitution's division of authority between federal and state governments. And then the next case along those lines decided by Justice Scalia in Prince, P-R-I-N-T-Z, Prince versus the United States in 1997. It dealt with issues related to enforcement of the federal Brady Act and the requirement for local sheriffs to perform gun background checks. And the court there held that it conflicted with the concept of anti-commandeering, which had been set out in New York versus the United States. So the court held that the duties imposed on county sheriffs under the Brady Act were excessive and amounted to a commandeering of local officials for a federal purpose. And what Justice Scalia said, the federal government may neither issue directives requiring the states to address particular problems, nor command the state's officers or those of their political subdivisions to administer or to enforce a federal regulatory program. And then he continued, such commands are fundamentally incompatible with our constitutional system of dual sovereignty. And the most recent case from 2018 that was decided by Justice Samuel Alito dealt with the issue of whether the state of New Jersey would be authorized to start up a legal sports betting program despite a federal law that prohibited such actions. In that case, Murphy versus the NCAA, Justice Alito said, the anti-commandeering doctrine may sound arcane, but it is simply the expression of a fundamental structural decision incorporated into the Constitution, and that is the decision to withhold from Congress the power to issue orders directly to the states. And he said, conspicuously absent from the list of powers given to Congress is the power to issue direct orders to the governments of the states. The anti-commandeering doctrine simply represents the recognition of this limit on congressional authority. Now, even more so, even when those three cases and those three Republican justices point out that Congress is prohibited from commandeering state authorities, even when Congress passes a law through both chambers of the U.S. legislative branch, both the House and Senate, and the law is signed into law by the President of the United States and is then a permanent law, even that is subject to the anti-commandeering provision. How much more so would a mere executive order be limited in its scope? Because as we've seen, President Trump is trying to do so many things by executive order, which does not involve an act of Congress, and therefore has significantly less status than an act of Congress passed by both chambers and signed by the president.
Yes. And Senator Looney, given that the immigration power is an executive power under the Constitution, how has this sort of come into play recently when it came to the ICE raids and the obligation of states to either be compelled to participate or not in those actions.
Well, we have a law in Connecticut that we call the Trust Act that says that when there is a federal request to issue a detainer for someone who might be looked to be taken into custody as an illegal immigrant, the state will cooperate with that detainer when the person has been convicted of a Class A or B felony, or when that person may be on a terrorist watch list. Other than that, the state is not obliged to devote its resources, its staff time, and its labor and its expenditure of money to carry out that federal order. Now, of course, federal agents can execute these things on their own, but they cannot commandeer state officials to be involved except to the extent defined in state law.
Great. And yes. And that's a foundational constitutional principle, which is what's important here is, and it's important that you mentioned that there are 3 Republican justices that supported that, because these principles are not partisan principles. These are foundational framework principles that establish the jurisdiction of states and falls under states' rights.
That's absolutely right.
And one of the questions here, so with that, Senator Looney, a question that had been asked before was, whether then the states can respond by having their own protocols in place, like judicial warrants, in order to ensure that those protocols are followed first. And that's perfectly within the state's jurisdiction to do that, again, under these constitutional principles of not being commandeered to follow federal mandates or federal requirements that go beyond state protocols.
Well, that's right. I think one of the things that will probably be a subject of litigation is at what point can the state rely upon its own procedural rights and guarantees and things that it may have adopted by statute or case law, as opposed to the federal claim that states are potentially obstructing the federal policy or the carrying out of a federal program. But as long as the state can rely upon these principles of federalism in these 3 cases and demonstrate what the state is doing is standing up for its own right to legislate and its own right to set policy, and especially the Constitution clearly guarantees in many cases the state's right to exert its police power, which has to do in many cases with either public health or public safety, because it is the state government that is the closest to those issues on the ground and needs to maintain order by adopting appropriate legislation in those areas.
And that's why I most wanted to have this conversation and focus on the constitutional framework, because these are principles that have been used by both parties to establish what the constitutional boundaries are. They're not partisan issues, they're constitutional issues. So I think it would be helpful, to be speaking in the language of the Constitution, because we've drawn these lines already.
We had some of these issues, obviously, we dealt with years ago during the civil rights era, after Brown versus Board of Education, when federal desegregation orders were issued, and in many cases there was resistance by the states, and obviously so there were some patterns that were established there to be followed, and others not. There was the famous case in Arkansas in 1957 when a federal judge issued a desegregation order for Central High School in Little Rock, Arkansas, and President Eisenhower at the time did not attempt to involve the Little Rock police or the county sheriffs or even the Arkansas State Police or even the Arkansas National Guard, because he may have suspected that in some cases they might have been more loyal to Governor Faubus and the point of view that he took in defying the federal order. But he sent in the 101st Airborne to escort those children to school for a significant part of that academic year. So obviously the federal government in that case brought in its own agents. But again, we have those 3 cases that indicates that the federal government cannot compel state authorities to be involved in areas where the purpose that's being sought is purely federal and is not something the state is part of.
And one of the questions in the chat, Senator Looney, is that, well, even if the Constitution is clear about this, there's no evidence that the Trump administration will pay any attention to that. So what can we do when they ignore those policies or those constitutional principles?
Unfortunately, I think they've already demonstrated a complete disregard for the Constitution on many fronts. So I think what we're going to see is a great deal of litigation on this. Our Attorney General William Tong, has already been in conversations with Democratic attorneys general from around the country to develop a legal defense framework and ways to challenge what are seen as improper and unconstitutional federal initiatives. And as I said, I think that in the none of these things that President Trump is trying to do have been passed as acts of Congress. They're all executive orders, and the scope of those have less authority than acts passed by Congress and signed into law by the president. As we can see, there were a number of executive orders issued by President Biden that were repealed by President Trump upon his coming into office. And the ones that he is issuing can either be repealed by him or by the next president. So while they have some force during the tenure of the president who issues them, that is not the same thing as passing a statute through Congress and signed into law.
Yeah, and this isn't, and this is why the constitutional question is so important, because this isn't only about President Trump. This is about allowing any future president to basically rule by executive order and override Congress, a representative body. And so we're now setting up the precedent that future Democratic presidents can also just rule by executive order. And that's a dangerous sort of precedent to set up when it comes to the separation of powers. So, that's what's really, I don't know if you want to add anything to that, Senator Looney.
Yes, well, very much so. And it's very clear that the budgetary power begins with an act of Congress. The Constitution, in fact, provides that the state budget, that the federal budget be passed by Congress. Spending decisions have to be made by Congress, and the president is then supposed to carry out those decisions. In fact, the Constitution even requires that taxing bills have to begin in the U.S. House of Representatives. And the theory behind that is that is the body that is closest to the people by having 2-year terms. And if they are willing to support a new tax or a tax increase, they're more likely to be responding to a genuine urgent need than perhaps the U.S. Senate, where the members have 6-year terms and 2/3 of them are not all that close to an election at any given time. So even that, you can see the framers had in mind the idea of making sure that there was accountability built in, that the body closest to the people, presumably if they would be willing to raise revenue, they're doing it in the context of a necessary, almost an emergency situation, so that the bill has to pass the House first, although it has to go to the Senate later.
Absolutely. And even those executive agencies, those were created by Congress. So it sounds like they're under the direct control of the president, but not without restriction. And what has been happening, especially recently, is with the firings and the freezing of funding, that's going beyond, without any congressional oversight, with this representative body, which is a real problem. And one of the questions,
one of the things, just one of the fundamental power or the fundamental obligations and responsibilities of the president is to see that the laws are faithfully executed.
yes.
That is a constitutional mandate on whoever the president is at a given time.
Exactly. And while presidents are able to attach conditions sometimes to that federal funding, it has to be related to the intent of the agency. It can't just be partisan issues that you happen to be interested in, because again, that could be then true of a Democratic president. So we don't want presidents to not faithfully execute the law and follow any kind of policy agenda, but really to follow the intent of Congress.
Absolutely. I think what we saw last week in terms of the lack of nexus between some of the requirements that were being put on federal transportation funding that had nothing at all to do with transportation, about having to do with population trends or masks or vaccinations and all of those things that have nothing at all to do with federal transportation policy. The fact that those would be connected is really an abuse of power.
Exactly. And then one of the questions in the chat, generally, I'm curious for your response to this too. Can Connecticut withhold our federal taxes and use the fund use to fund the programs we deem necessary if President Trump denies our federal funding to try to coerce the states to implement a particular agenda?
Well, I don't know how we could do that directly, because we don't, our taxes are paid by individuals to the federal government. Not the state is not paying taxes. The individuals who are state and federal citizens are paying taxes. So I don't know what the mechanism would be unless individual citizens decided to not pay their federal taxes in protest. I certainly would hope they'd continue to pay their state taxes, though. But the other thing, of course, is that it is true, that does raise the point that Connecticut, in the aggregate, pays a lot more in federal taxes then it gets back in federal revenue because we are a wealthy state. We have a number of very significant federal taxpayers in Fairfield County and other parts of the state, so that the net balance is an outlay from the state to the federal government rather than from the federal government into the states, as it is in many other states, especially in the South, where the federal income tax revenue is much less on a per capita basis than it is in Connecticut.
Absolutely. So another question here is, will Connecticut, or how will Connecticut, I would say, be able to continue its leading role in addressing climate change now that the administration has, the federal administration has adopted such a hostile stance towards this work?
Well, I think we need to maintain our commitment, recognizing, though, that because we are a small state, we are not in a position to affect national policy in many ways. Obviously, the state of California was able to affect environmental regulations in many ways, and establish regulations that that automakers and others wanted to comply with, so that in many cases states were given the choice of adopting either a federal standard or a California standard. But the difference is California has 39 million people. We have 3.6 million. But to the extent that we can have an impact in terms of climate change and putting down a marker for environmental concerns, we should certainly continue to do so.
And actually this leads into this next question. How will Connecticut's participation in multi-state coalitions then, given what you just said, Senator Looney, enhance our position on key issues and strengthen state-based protections in response to the actions of the Trump administration?
Well, that is going to be important because we are one of the smaller states, but we have, I think, fellow thinking larger states nearby. So obviously the possibility for coalitions involving Massachusetts, New York, New Jersey, perhaps Rhode Island, so some of the New England states plus New York, New Jersey, that creates a much larger critical mass. Other generally progressive states like Maryland might be part of that coalition, Illinois, and of course California. So when you put those together, you've got a pretty substantial block.
Absolutely. And that's why I say come back to, it's important for us. I'm glad we're toward the end, we're ending on what Connecticut can do, because we've been doing a lot to create those extra protections that go beyond the Constitution. One other question here is, can something be done to reassure public school educators that the state laws about the LGBTQ community, about equity in the curriculum, and events like Black History Month will not be changed? So to make sure that our commitment to basically equality remains despite the directives and executive mandates that may be coming down from the federal government.
No, absolutely. That comes squarely within the cognizance of the states, and it's our intent to make sure that we maintain our commitment in those areas, and our recognition that we are going to be protective of the rights of every group, especially minorities who face discrimination.
And we have the oldest state civil rights agency in the country, and that's the Commission on Human Rights and Opportunities. And we've provided robust protections for groups even beyond the federal Constitution, which again, we're allowed to do because we have a separate autonomous jurisdiction from those federal constitutions. And so that's so important when it comes to—
Exactly. And that's in fact one of the questions that when I was a member of the Judiciary Committee that I would always ask nominees to serve on the state appellate court or the state Supreme Court, is that are there areas in our state constitution that you believe grant greater protections than those in the federal Constitution? Because the federal Constitution is a floor and not a ceiling, and that states are free to grant additional individual rights and liberties beyond those contained in the federal Constitution, but are not allowed to do less.
Absolutely. And we're looking to our state now, I think, really to provide that leadership and that hope. This is a question, I know Senator Blumenthal's not on, but Senator Looney, what are your thoughts on this, about whether the president is able to abolish agencies like USAID or transfer that funding effectively to the Department of State?
I think that's something that's going to have to be litigated. I think that in some ways clearly that's something that Congress could choose to do, I think, and to reorganize government in that way, and pass a bill that the president could sign. But for him to do it unilaterally, I think that raises questions of abuse of power.
Great. I think that's why I wanted to make sure we focus on the constitutional framework, because we have a foundation of accountability. And that's why I started with that provision that most people don't talk about, which is abolishing, no titles of nobility, because you're serving the office and the office is serving the public. And there has to be that public accountability piece. So to allow the executive to basically have no oversight over freezing or extending funding to agencies seems foundationally problematic. It's not something the framers would have put in place.
Right, right.
Absolutely. Yeah, so I think we answered. I guess one question here is, can Elon Musk be challenged in court? And if yes,
I would hope so. I would say that.
or the appointment.
I know
Yeah,
Senator Blumenthal addressed that earlier, that somebody basically without any appointment, without any confirmation, and really without any official portfolio, is in fact doing something that is extraordinarily disturbing about violating the confidentiality of records held by the U.S. Treasury. That's really running amok, I think.
exactly. Yeah. So this is where, we're both constitutional scholars. So with a commitment to the Constitution, we're seeing, again, a number of issues here, whether it comes to executive agencies, whether it comes to the use or freezing of funding, appointments that go beyond congressional oversight. And then the other thing, that comes up here and that I wanted to ask you about is freedom of the press. There have been recent executive orders that are specifically targeting certain organizations in the press, and that looks like it's basically targeting viewpoints in that same way. And that seems to be right on its face unconstitutional. And if you have any thoughts on that, Senator Looney.
Yes, I agree. It is. My overall concern is that there seems to be a growing consolidation of media outlets, and too many are in the control of right-wing leaning ideological organizations now, and that's really dangerous, that you don't have the broad-based diversity of opinion being expressed with people having access. And the more you have consolidation in that area with powerful reactionary forces controlling so much of the media, there's a real danger there that there won't be a fair and sufficient number of outlets for public debate if that continues.
Absolutely. And this last question here is, how can Congress reassert its core constitutional responsibilities?
Well, I think the members of Congress, the Democratic minority in Congress, has to speak out on every point, challenge the Trump administration on every issue. I hope that they will rise up and oppose some more of Trump's nominees for positions, especially where they are obviously unfit, and continue the fight. I think they need to be as challenging and as staunch in opposition as the Republicans were to President Obama when he came in.
This is really challenging because so much of it is unprecedented. And I know several individuals have asked, what is it we can do as a community, as individuals, looking at the unconstitutional reach of a lot of these executive mandates. And I almost don't, so I'd love to hear your suggestions. My initial thought is you have to write to your legislators, because, again, a lot of these executive agencies are under the oversight of Congress. And it's coming to the point where both the minority party can push pressure on the majority party to say, look, this is blatantly unconstitutional. We have our framework in place. It's not a partisan framework. We have to start acting. So besides writing to legislators, about this, do you have any suggestions? People want action items for what they can do, Senator Looney. What do you think we can leave them with?
Well, I think what they can do, it is important to communicate with our two U.S. senators, Senator Blumenthal and Senator Murphy, who has also been a leading spokesman in opposition to some of the things that the Trump administration is doing. And our 5 members of Congress, unfortunately, all 7 are in the minority currently, both in the Senate and the House, but they can still be help to be a focus for the national debate, especially when they have a broad-based mandate of support from their constituents, communicating with them on the outrages that we're seeing coming from Washington in the executive branch every single day, it seems.
Yes. And I would hope that people also continue to speak up. It feels very exhausting because, again, it's a flurry of activity, and a lot of it is unprecedented, and a lot of it is unconstitutional. And so we're responding to a lot at the same time. But I think, and that's why thank you so much for joining this, Senator Looney, to bring this to a constitutional framework and those constitutional foundations, because I think we need to be speaking in the language of the Constitution. This isn't about one party versus the other party. This is about a fundamental system of government that we need to protect to make sure we protect our democracy. So I hope people keep speaking in that language.
I think that that's important because the Trump administration will pass from the scene, and it is important that that we not allow our system of government to be destroyed in the process, because we need to continue and reassert all of these principles that have been so important to us all of these centuries. And I think it's people need to, I think, regather their enthusiasm and their interest. You recall in 2017, there were massive demonstrations against President Trump when he was first sworn in. In fact, he got sidetracked in his original inaugural speech in arguing about whether his crowd was bigger than the crowd of women demonstrators who had come out against him. But we haven't seen that yet in terms of a public outpouring this time. So I think people to some extent may have been discouraged by the results of the election, but they need to, I think, just recharge the batteries and get out there and continue protesting, continue arguing, and continuing to be a witness for what we believe our government should be in terms of protecting the rights of individuals, protecting the rights of states, and making sure that none of our constitutional principles are trampled upon.
Absolutely. No, thank you so much. And I will always like to leave on a high note, because I'm an optimist. I'm an eternal optimist. And I know that things, as you say, well, we have to work towards progress and work towards improvement. So if you can leave us with something you're proud that the state is doing to protect people, to leave them with that kind of that glimmer of hope,
Well, the state has done many things over the years in terms of protecting the rights of minority groups to the extent greater than federal law in some areas, protecting the rights of workers to organize, protecting those who are low-wage workers by providing for a significant increase in the minimum wage and for paid family and medical leave, paid sick days. In fact, we are doing the kinds of focus on the day-to-day issues of working people that some are faulting the National Democratic Party for not doing. And we are seeing the results here in the state. We have gained Democratic seats in every election since 2016, when we were in an 18-18 tie with the Republicans. Since then, our numbers have increased to 25, and their numbers have dropped to 11, and now 10 because of the vacancy. So we here in Connecticut are doing what the people want. I know there have been some polling that shows that the National Democratic Party is not overall popular right now, but we are doing what the people want here in Connecticut, and that's showing in the election results we get here.
And we're going to keep doing that work, because that's important no matter what the federal government is. And we have our own state, our own jurisdiction, and that's what we'll continue to do.
Absolutely right.
Thank you so much, Senator Looney, for taking the time to be here for the entire time. And, I hope that we will continue to do, a series of these conversations and keep focusing on these constitutional issues that really, that are at the core of what makes us American, is our commitment to the Constitution.
Great. Thank you, Senator.